Every year, thousands of people get sued by junk debt buyers like Midland, Portfolio, Cavalry, and LVNV. And yet so many of the people who get sued lose their cases. Very, very few are able to win. What makes a loser into a winner? Today, that's the question we're going to answer. My name is Mike Wasylik. I'm one of the lawyers at Ricardo and Wasylik here in Florida. And together with my partner, Jason Ricardo, I help people just like you overcome debt collection with dignity. And today, we're going to talk about getting sued by junk debt buyers and how you can avoid being a loser and become a winner. If you've been sued by a junk debt buyer like Midland, Portfolio, Cavalry, or LVNV, drop a comment below and tell us who sued you, what state you're in, how much they sued you for, and how that worked out for you. And at the end of the video, let us know if what we're talking about matches your experience. The lawyers in our firm have been defending debts specifically for over 15 years now. Both my partner and I have over 25 years of experience as lawyers, and we use that to help people overcome these debt collection lawsuits. And we deal with these junk debt buyers on a regular basis. These companies, these junk debt buyers, they buy up bundles of debt, charged off credit card debt, for pennies on the dollar. And then they try to collect it from people just like you for nickels, dimes, and even quarters so that they can make a profit. Some of these are billion-dollar corporations, and all they do is debt collection. And because the credit card companies are always willing to sell off charged off debt, these companies have an unlimited supply of people to go after. And many of those people are here in Florida. If the letters and phone calls don't work, they sue. And they sue here in Florida, and they file thousands of lawsuits every year in Florida. And the overwhelming majority of those cases end up in judgments against people here in Florida, and companies like Midland, Portfolio, LVNV, and Cavalry will take those judgments and they will use them to garnish wages, take money out of your paycheck involuntarily. They can seize bank accounts and other assets, and other ways they can squeeze money out of you without your permission. But even though that's what happens to most people, there's a very small number of people who are able to win their cases, get their cases dismissed, and never look back. They're done for good. So you're probably wondering, what's the difference between the people who lose their cases, who suffer from garnishment of wages, who have their bank account seized, who have their other assets seized, who have this permanent black mark on their reputation, and then those who win their cases? What do those winners do differently? Well, we've wondered the same thing, and we have talked to a number of people on both sides, people who have won their cases and people who have lost their cases, and we found the 4 mistakes that the winners have been able to avoid that leads everyone else into a loss. Number 1, people lose because they ignore the case. I can't tell you the number of people I've talked to who come to me with a wage garnishment saying, I didn't even know about this lawsuit. It was a complete mystery to me. I don't remember being served. It's very unusual for it to be a complete surprise. There's usually some kind of indication. There's some kind of knowledge that somebody out there is trying to collect a debt from you. Maybe it's the phone calls you didn't answer. Maybe it's letters that you didn't open. Maybe it's the court papers you didn't read. But for whatever reason, many people just do not respond to a lawsuit in time to actually do something about it. What happens when you don't respond to a lawsuit? The summons tells you you either have to show up. If it's a small claims court, you have to show up in court, either in person or for a Zoom hearing. Or if it's a larger lawsuit, you might have to file a written answer. If you fail to show up and you fail to file the written answer, if you don't do the right thing at the right time, you will lose. The judgment will be entered against you, and then the junk debt buyer is now the successful judgment creditor, and they will proceed to garnish your wages. They will try to find bank accounts they can seize, and they will look for other assets of yours that they can take from you. People who win their cases, they don't make that mistake. They do the right thing at the right time. They show up when they're supposed to, and if required, they file a written answer with appropriate responses. Mistake number 2. When making that initial response to the lawsuit, people who lose usually make some kind of fatal admission. They say the wrong thing to the judge, they put the wrong thing in their papers, and what they don't realize is that they are actually admitting that they owe the debt. They are admitting that a judgment should be entered against them. Here's the best example. The most common fatal admission I see people make is, I just don't have the money. The problem is, poverty is not a defense. You've admitted owing the debt. You've admitted you haven't paid it. You're just trying to say that you can't pay the debt. But your inability to pay is not a defense. It is an admission of guilt. So what do the winners do differently? They know that they shouldn't admit the debt. They know they should show up in court and deny the debt, or at least deny knowledge of the debt, and ask the judge to make the other side prove their case. And if you're filing a written answer, you would do something similar. You would deny the allegations from the other side and ask them to provide proof of their claim. Mistake number 3, taking a passive approach to defense. A lot of the advice you'll hear online is, well, just show up and make them prove their case. Make them produce the evidence because they don't have this document or they don't have that document or whatever the advice is online that you might be hearing. The problem is that most of that advice is wrong because the lawyers for these junk debt buyers always have some kind of documentation. And whether or not you agree that it's enough proof to prove their case, it's usually the type of document the judge expects to see, and the lawyers for the other side are going to meet that judge's expectations, and the judge is going to be very comfortable entering a judgment against you unless you have a real defense. Just sitting back and saying make them prove their case is going to end up more often than not in a loss for you. Are there rare cases where the debt collector's lawyer will show up and not have the proof that they need? Yes. Are there rare judges who will hold them strictly to everything they need to have and will review the evidence very, very carefully to make sure that all the T's are crossed and all the I's are dotted? Yes, that does happen. But the vast majority of cases, the judge has an enormous docket. They're going quickly. They don't have time to do your job for you. And if the lawyer for the debt collector has the bare minimum of the documents that they need and presents them confidently enough, most judges are going to accept that on face value. So what do the winners do differently? They know exactly what the other side needs to prove. They know exactly what documents to expect. They know exactly what documents the other side's going to bring in. And most importantly, they know specifically what documents are missing and why they matter. Mistake number 4, using the right tool in the wrong way. There are some people who are very familiar with debt collection and know exactly what the other side needs to prove in order to get a judgment against you for debt collection. They might know, for example, that the other side has to prove that they actually purchased the debt and they have to provide documents of that. They might know that the other side has to prove that they mailed the statement in certain types of claims. They might know that the other side has to prove that the amount was unpaid. But just because they know those defenses exist does not mean they know how to use them. What I often hear is that people take these tools that they have and they will argue them incorrectly. They will not understand them completely enough in order to be able to convince the judge. They will not be able to direct the judge's attention to where the proof is deficient or provide proof of their own that something is wrong with the debt collector's case. So what do winners do differently? They have a deep understanding of the legal claims that are involved and the legal defenses. So for example, most junk debt buyer claims involve a claim called account stated. Now, account stated doesn't require a wedding contract. It doesn't require anything except the plaintiff prove that a statement was mailed, that it was received, and there was no objection within a reasonable time, and the law will then assume there's an agreement that the amount is owed. A winner will understand what an account stated claim is, what the defenses are, and how to deploy them in the courtroom, how to argue them in front of the judge in a way that will be not just legally sufficient and logical, but also persuasive. There's one other way that some people take an otherwise winning case and turn it into a loser, and that's by failing to get the help they need. Now, everybody's going to need a different level of help. There are some people who are completely comfortable speaking in public. They're completely comfortable standing in front of the judge and explaining their case in the proper way, in the persuasive way. There are some people who are able to take the time to do the extensive research necessary to understand the legal claims, to understand the legal defenses, and the techniques for how to present them to the court. There are some people who have taken the time to know the rules of the courtroom, how the courtroom operates. They know how that specific judge likes to operate, and they know what arguments are most persuasive to that judge in a junk debt buyer situation. And there are people who are able to take all of those things together and deeply understand what they need to do in order to win their case. There are very few non-lawyers who are able to do all of that, especially for your first time being sued. Even lawyers who have years of training and libraries full of knowledge crammed in their heads have a difficult time the very first time they walk into court. Most people are going to need some kind of help. The number one factor we've seen is that people who get dismissals are the ones who have hired a lawyer to appear for them, to make the arguments for them, to try the case for them, to win the case for them. Now, if you want to do it yourself, hold on for just a minute. I'm going to give you some valuable information. So if you already know that you need help, I'm going to put a link in the description below for you to contact us to get Florida help for Florida cases. If you're in another state, you should look for a lawyer near you. Look for somebody who handles FDCPA or debt defense cases, ideally one who's written articles or maybe done a video about your specific debt collector. For those of you with the confidence, the knowledge, the skill to handle it yourself, you're going to need to know about account stated claims, how to defend them. So you need to watch this video I'm going to put on screen right now, and that's going to help you a lot. Thanks for watching. I'll see you on the next one.